Ag agreements can be used to allow somebody to conduct farming on behalf of a landowner. And since the status of an individual can differ, it's important that all parties understand the legal nature of the relationship to avoid litigation. It's the name of the game these days. Roger McEowen with the Washburn University School of Law joins us now with guidance in today's Rural Money segment. Thanks for joining us, Roger. So what is the difference between an employee, a cropper, a tenant, and a custom cutter?
Well, that's a really good question, and it can get farmers in trouble in unexpected and unanticipated situations. And it's pretty clear what an employee is, particularly if you have a written employment agreement, which sometimes we suggest that farmers formalize those agreements. But that's somebody that you're controlling the method and the means and the mode and the operation of what they're supposed to do for you, and you pay them for their services. A tenant, on the other hand, has a property right. They have a possessory right in the land itself. They have a right to be there by possession. And, of course, if they're a tenant, they're entitled to statutory notice of termination when the lease ends. And if you're operating under an oral lease, there's a set of state laws that tell you when you're supposed to, the notice that you're entitled to before you are supposed to leave the premises. But if you're a custom cutter, you're basically just an independent contractor. You have no legal property interest in the land. Same thing for a cropper. And a cropper's kind of in the middle between a tenant and they're not a tenant. They don't have a property interest. They just have an interest to be compensated for their labor provided, so they're not like a tenant, and they're not really like an independent contractor. They're more like a special category of an employee. They're a wage earner that is hired to produce a crop.
You know, that's interesting. It gets a little tricky there, the distinction between a cropper and a tenant. It seems to be especially critical. Why is that the case, Roger?
Well, because we can get into all types of issues. I think the big issue, one of them in particular, is if I'm a cropper, I'm not entitled to statutory notice to terminate the lease. If I'm a tenant, I am. We had a recent case in Arizona that brought this up, this issue between a tenant and a cropper, and what happened was that the farmland actually got condemned, that the individual was farming for this, actually it was a three-party deal. The individual that was paying the person to farm was leasing it from a third party, but long story short, the property gets condemned, and so now there's a battle over the condemnation award, and the individual here that was farming said, I have a lease, and therefore I'm entitled to one half the amount of the crop loss in settling the condemnation matter, $500,000. The other party said, no, I just hired you to harvest the crop. We didn't enter into a lease agreement, therefore all you're entitled to is $10,000 of lost profits. Humongous difference. And the court said, based on the facts, yeah, he was just a laborer. He was just hired to harvest a crop. He's entitled to his lost profit. He's not entitled to the $500,000 of the crop loss itself. Makes a huge difference. Now, that's a unique set of facts, but very big difference. So understand your classification if you're harvesting crops for somebody else.
Absolutely. And you know what? You do such a great job of laying it all out on your blog. I want to make sure everybody has that website, washburnlaw.edu/Walter. Roger McEowen with the Washburn School of Law, thank you so much for joining us.